welcome to Business for One class. Today we look at Section 3 of Unit 3, Vitiation Factors, specifically mistake, session objectives. By the end of this session, you should be able to explain the term mistake, 8 types, describe common mistake and 8 types, describe unilateral mistake and 8 categories, and also appreciate mistake as to identity. Now, in contrast law, to be mistaken is to be wrong as to the matter of fact that influences the formation or making of a contract. So the definition of mistake in law is different from the normal mistake we know. Contract law recognizes 3 types of mistakes. We have the common mistake. With common mistake, both parties make the same mistake. We also have mutual mistake, where the parties are at cross purpose. And the last one is the unilateral mistake, where only one party is mistaken, but the other party is not making a mistake. Where the contract or where the court make a finding of mistake, this will generally render the contract void ab initio. What it means that when the court determines that the contract is tainted with mistake, the contract is void and it will be treated as it did not come into existence. Where a contract is voidable, you're saying that the contract exists and it is valid until the innocent party takes action to set aside the contract. Now you should understand that with a voidable contract, if an innocent third party acquires it in good faith, the innocent party will obtain title to those goods. If a contract is void, the party who acquired those property will not get valid title to the goods because the contract is already void or void at the beginning. So let's deal with common mistake. Common mistake exists where both parties to the contract make the same mistake. And we have different categories. We have res extincta, we have the res sua, and mistake as to quality. Res extincta simple means that the subject matter of the contract is not in existence at the time the parties were entering into the contract, and the parties were not aware. That's what you mean by mistake, which is categorized as res extincta. Res sua, here the purchaser is the original owner of the property in question, but this fact is unknown to both parties. So for instance, if your father has many houses and there's one of the houses that it has been registered in your name, but you don't know, your father has appointed agent to deal with those houses. You meet this agent and you purchase the house. Unknown to both of you, your father indicated that this building or this house is yours already. So a clear example of res sua. We also have mistake as to quality, only available in very narrow scenario or limit. So we are looking at mistake affecting the quality of the subject matter. So mistake as to quality. A mistake as to quality is only capable of rendering a contract void, where the mistake is as to the existence of the some quality which render the subject matter of the contract essentially different from that which it was believed to be. So a mistake as to quality will only render the contract void if the subject matter which has been provided is radically different from what the parties initially entered. A mutual mistake, that's where the parties are at cross purpose, the court will apply the objective test to see if the contract can be saved. The objective test here, you're looking at what a reasonable man, given the surrounding or given the facts, what conclusion would that person arrive? Would that person say that there was a mistake or there was not a mistake? In the case of Raphael v. Wikihouse, while the defendant was thinking of the ship which was due to leave Bombay in October, the complainant was referring to a ship that was to leave in December. So, whilst one person is thinking of the ship coming October, another person is also talking about the ship that is coming December. The December ship and the October ship were all named as Bombay. So they were not adding them. They were at cross purpose. One is thinking the Bombay ship coming October, another one thinking of Bombay ship coming in December. Unilateral mistake. So here only one party is making a mistake and the other party is not making a mistake. You have two categories. You have mistakes relating to the term of the contract and mistake as to the identity. When you look at the mistake as to the term of the contract, you are saying that for mistake to be operative, the seller needed to know that the buyer was mistaken as to the term of the seller's offer. What was mistaken must be condition of the agreement. So, Hatton v. Cullen and Shield illustrate this principle. So, the buyer must aware that the seller is making a mistake on the terms. Mistakes to identity. So, we are saying that mistakes as to identity are generally induced by fraud, in that one of the parties is claiming to be someone who they are not. So, you claim to the other person that you are a particular person, meanwhile you're not that person. The court in determining whether or not a contract will be held void for mistake, the court draw a distinction between contract made inter absentee, that's at a distance, that's where you are not in face to face, like online, on phone calls. Then the court also distinguish contract made inter presentee, that is face to face transaction. And these are governed by different principles. So with inter absentee, that's where parties are not transacting face to face. Where the parties are not physically present when the contract is made, that's where the contract is made through post, telephone, or internet, as we indicated earlier on. The court will only make a finding of mistake if the claimant can demonstrate an identifiable person or business with whom he intended to deal with. So here, the key word is that if you are claiming mistake as to inter absentee, then you should be able to demonstrate that you did not intend to deal with the person who claimed to be another person, but you intend to deal with what? A particular person. That person exists, or a particular company or business. So in the case of Candy v. Lindsay, it was heard that the contract was void because, or the contract was void for unilateral mistake, as the claimant was able to demonstrate an identifiable existing business with whom they intended to contract with. So all what you are required to do is that you demonstrate or you show that indeed you intend to deal with another existing person or business. However, you should know that a mistake as to attributes will not suffice. If it's just attribute or the person's character, it will not suffice. Inter presentee, that's where you are transacting with the person face to face. The law provides that where parties contract in a face to face transaction, the law raises a presumption that the parties intend to deal with the person in front of them. So if you meet someone and you transact business with a person, the law presumes that you intended to deal with the person before you. And the case in question, Philip v. Brooks. Philip v. Brooks, that demonstrates inter presentee, that face-to-face transaction, where the law presumes that you intend to deal with the person that is before you. You also have the issue as mistake in relation to execution of document. non ex factum. As a general principle, a person is bound by his or her signature to a document whether or not they have read or understood the document. What this means is that once your statement is on a particular document, the law will hold you responsible for whatever contained in the statement or the document. It doesn't matter whether you read the document before you sign or not. Now, the plea of non ex factum is a form of a mistake over a document by which a party says that the deed which he executed is not binding on him because of some circumstances which shows that it was not intended to be his deed. It normally protects the blind and illiterate, although not limited to only blind and illiterate. As far when the rule was established, it was basically to protect the blind and illiterate. But the fact that you say you are illiterate does not mean that you didn't attend formal education. You can be a professor, all right, but if you don't have knowledge in a particular subject matter or language, you are illiterate in that manner. For instance, if you are a professor and you don't understand French or Greek, and document is written in French or Greek, you will be considered as what? Illiterate, because you cannot read the French or the Greek. It's related to essential nature or character of the document. The mistake must not be as the legal effect of the document. Now, before you can plead non ex factum, this is what I did. It has 4 essential features. There must have been a mistake. The one who made the mistake was misled in making the mistake. Mistake relate to document radically different from what one thought he was signing. The one seeking to rely on the plea should not have been guilty of negligence or carelessness. So if you want to rely on non ex factum, you should be able to prove all these 4 elements. If you are negligent or you are guilty of negligence, you cannot rely on the plea of non ex factum. So in the case of Foster v. McKeown, the defendant was a man with a poor eyesight, and this man was induced to sign a contract which he was told was a guarantee. In fact, it was a bill of exchange upon which the claimant ultimately became entitled. It was held that the defendant, who had not been negligent, was not liable on the bill. The plea of non ex factum succeeded. So if the defendant had been negligent, then it will not be successful, or the plea will not be successful. In the case of Saunders v. Anglia Building Society, an elder widow wished to transfer the title of her house to her nephew by way of gifts. However, her nephew and a man named Lee prepared a document assigning the property to Lee and asked her to sign. She signed it and read as she had lost her spectacle and trusted her nephew. Lee mortgaged the property to the building society and disposed of the money raised for his own use. He defaulted on the repayment, and the building society sought possession of the house. Sanders sought a declaration that the assignment to Lee was void by reason of non ex factum. The court gave this ruling. In view of the both Court of Appeal and House of Lords, the plea could not succeed. These are the reasons. 1. The transaction the widow had entered was not radically different from what she intended at the time she entered it. 2. She had been careless in signing the document. Remember, you said that if you are careless, the rule will not prevail or you will not be successful. So, because she had been careless in signing the document, she should have gone for the spectacle. She could at least have made sure that the transfer was to the person intended by her. So looking at all these things, you know how the mistake operates and its effect. We have attempted to look at the various types of mistake and its implications. Thank you and have a nice day.